Hi, everybody. This is Richard Bolger, my second episode here on the new podcast series I am doing about bankruptcy, a subject matter I have been practicing law in for over 30 years and thought, hey, got some great information, helpful stuff for people. Bankruptcy is an embarrassing topic. Nothing like being able to go online and learn without everyone knowing what it is you're asking about. Okay. So, I thought today I would talk about one of the most common questions I get asked by people. Hey, what do I have to include in my bankruptcy case? Or do I have to include this? Or I want to put this debt in and I want to keep this debt over here, this credit card. I want to keep it. So the question is what do I have to do? What do I have to include in my bankruptcy case? And the answer is quite simple. You have to include everything in your bankruptcy case. The question really that you're asking me is, what is going to happen to my stuff in bankruptcy? What's going to happen to my debts? What's going to happen to my property? Because at some point, you are signing a petition under oath, under penalty of perjury, and you're also testifying under oath under penalty of perjury. So you're going to be telling the truth if you're my client. In fact, the only way that a person can screw up their bankruptcy case is, well, there's two ways. One, you're not honest with your lawyer and you're not telling your lawyer everything they need to know. And secondly, another honesty issue, you're not honest with the court. Okay, so you're not being honest. If that is determined that you're filing fraudulent statements, you're omitting serious matters, significant asset or debt, in order to manipulate a particular creditor, then you're going to be possibly in trouble and not eligible for a discharge. So, rule number one, tell the truth at all times. And rule number two, make sure you tell your lawyer the truth at all times. The lawyer will tell you the ramifications of these questions you have. Don't worry about the answers. Tell the lawyer the truth. They'll tell you what's going to happen. You can decide if you want to go there or not. The best lawyers in this business are ones who have enough experience to know before they file what it's going to look like when they're done. If you have a lawyer who's seemingly, being surprised all along the way, then you're going to get quite worried, and for good reason. So when sometimes on a related matter, sometimes when people are told what's going to happen with their, say, asset, maybe their car, for example, they don't like the answer, and so they go, "Well, man, can I just transfer that to my parent, and give it to them, and then I'll file a bankruptcy case because then I won't have it anymore." Well, you'll see in the course of a bankruptcy case that there are a lot of questions regarding transfers of property and payment of debt in the time frame before you file. So basically, everything you might think of doing has already been thought of before, and the courts and the Congress and drafting legislation have pretty much thought of it and addressed these things as well. So the best thing to do is to tell the truth. For example, say you did give your car to your mother, last month, and it has equity in it, it's got value, and that's why you were transferring it. Well, you can be advised that, all right, not time to file a bankruptcy case. Maybe you have to wait. Transfers to family members that occur in a year before you file are going to be looked at with a jaundiced eye. Okay, so you might say, okay, I'll come back later, file later. But oftentimes, the creditor is setting the agenda, pushing the timetable, filing a lawsuit, threatening you with collections, harassing you, and you cannot wait. You still need to be truthful at all times and be sure to include in your petition all of your debts and all of your assets. When if, for example, you're in a Chapter 7, which is a liquidation, you may not have an asset that's really worth worrying about, but you think it's something of value. I find most people are overvalue their things, and most of the time it's not a great liquidation value to them, and they're not really worth anything to their creditors. So don't be too worried. Tell the truth, and that is my kind of last comment for the day. Really, the only way you can mess up your own bankruptcy case is to not tell the truth. And that starts with talking to your lawyer and then, of course, testifying before court and signing pleadings that are submitted under penalty of perjury. Next, we will have something hopefully that you are interested in learning about, and hope to talk to you soon. Okay, bye.